Well, after every good stretch break, we always love some stats to bring things back into focus. I'm actually going to run through some of these statistics pretty quickly, and I know that there's a lot of different backgrounds. I mentioned AI just because in deep learning, that's where a lot of the software innovation is happening, and it actually stretches across a lot of other fundamental areas of technology. So without further ado, I think we know what we're talking about in terms of AI. I always find it's interesting just to see what people in the industry are doing. Certainly from the corporate perspective, companies like IBM, Microsoft, Toshiba, Samsung, we've got Alphabet up there. These are the main developers of artificial intelligence just by numbers of patent applications filed. I thought it was interesting in terms of academic academic institutions that are filing in AI. You see a lot of Chinese universities and institutions. One of the things is that China has actually been trying to promote more filings of artificial intelligence and software applications. And so the government actually gives subsidies based on the numbers of filings. And so we see a lot of the filings from Chinese research institutions going up there as well. Just a breakdown of some of the AI spaces, neural networks, machine learning. You just kind of see a little bit of the balance between what's being published and what's being patented. There's still a lot of controversy on how much of the software can be patented. It's a tricky line to walk, but you can see here. And you'll have these slides so you can go back, and if you're particularly interested in any of the data, you can see that. I thought this was interesting. This comes from a report of the World Intellectual Property Organization. Did a full study on this, and they said that AI is now disclosed in 1/3 of all patents that are being filed, which I thought was interesting. On this particular slide, you can see some of the, it's a little hard to tell, the darker purple lines are the general categories, the lighter purple are subcategories within that. And so you can kind of see the numbers that we're looking at here. I just highlighted, for example, life and medical sciences. In all of these different aspects, you have software, deep learning that is undergirding innovation in these areas. Again, just looking at the growth over time, you've got 1980 on the originating point on the x-axis, and this goes up to, I think it goes up to about 2017 in terms of data. I should mention that patent applications only publish 18 months after they're filed. So if we're just looking at the patents, we don't know anything that's happened in the past 18 months because things just aren't published. Companies can kind of fly under the radar and keep it secret at least for 18 months. By the way, unpublished patent applications can also be considered a trade secret in some regards. So these are some of the industries, and you can kind of see in the mid-2000s how things just kind of really went up in terms of the number of AI patent applications being filed in various industries. Top filers in AI, this kind of just breaks down that list of companies in the rows, and then across the columns are the areas of technology that people are filing in. Again, just looking at the example of life and medical sciences here. Interestingly enough, companies like Siemens and Fujitsu, which you wouldn't necessarily think of as a life and medical science company, are some of the top filers. But this is because, there's so much innovation in the life and medical sciences around taking biometric data. I mean, we're all walking around with watches and fobs, and you can think of hospitals where they have all the data that's being taken in. What do you do with the biometric data? How do you store it? How do you analyze it? And so some of these traditional electronics companies and traditional software companies are taking the lead even in the life and medical sciences space. In terms of patent office, US is the most active patent office in terms of number of filings, followed very closely by China, and then Japan, WIPO here, the PCT, EPO, and you can see the rest of the list. Thought it was interesting, the first filings, China actually edges out the US. This is where a family of application is first filed, doesn't claim priority to any previous application. As I mentioned, China offers currently a subsidy for first filings in artificial intelligence. Time will kind of tell how that affects the rest of it. You know, are they just filings that will ultimately issue into patents, or are those filings that become abandoned later on down the road? In terms of families, the U.S. this is just, for example, in life and medical sciences, the U.S. is leading the way there. And just one thing about anytime you're dealing with software, the difficulty of patenting software and algorithms and analytical methods isn't just an issue in the U.S. It's maybe most prevalent in the U.S. just because the law has been in flux over the past 10 years now. But there's also things you have to think about from other countries and what their requirements are. A lot of software, especially on the analytical side and the informatics, it's based in math or mental processes. And mathematical concepts are not traditionally considered inventions that the patent office wants to allow to patent. Applications of math, yes, but fundamentally math, no. And so trying to draft the applications and craft claims in a way that makes it clear this isn't just doing math, but this is actually an application of a mathematical process is one of the things we have to look at. One of the other issues with software applications, particularly when you're dealing with deep learning and you have your machine learning algorithms, neural networks, things like that, where you don't necessarily know how the computer is reaching a particular result. I train my algorithm with data, and I know what data I fed into it, but I'm not necessarily sure what the algorithm is considering as the key parameters that are indicative of a particular result. And so if you're trying to enable an invention in a patent application, how do you really do that? One of the requirements of patent applications or patented inventions is that they be reproducible, that somebody else can read your disclosure and kind of reproduce the same result. That's just very difficult in the deep learning perspective. And then also, detection. If you can't detect it, why patent it? Is it better kept as a trade secret? Those are some of the issues that you have to think about when you're considering patenting in the deep tech sector. These are just allowance rates in different technologies. Allowance rates, interestingly enough, tend to be higher in the electrical computer space. That's not necessarily because of software. Software is generally considered low, and in fact, software often, where it says 3,600 here, that's where a lot of software goes. It's called the Business Methods Art Unit. But also in these electrical computer art units are architectures, real physical things, and so that's why you see a higher rate of allowance. And then I'm just going to skip through these. These are, if you can go back and look at them later, they're just allowance rates for different technologies over the years as the law has changed. So there are just some numbers that talk about trends. Happy to answer questions later on if about anything we're seeing on the software side. But I thought it'd be more interesting just to skip through those quickly, and let's turn it over to Don for how do you come up with a strategy that's important to your business and specific.
Well, interestingly enough, there's been some color commentary by both Gaby and Michelle and I all the way up to this point concerning a lot of the fundamental underlying points with regard to return on investment and the things that you need to think about for that. So even skip to the next slide, Michelle. I think for ROI, we need to focus on intellectual property budgets and monetization of the IP is really kind of where the rubber meets the road. And we need to think about you folks that are on boards or board of directors and what the fiduciary responsibilities of those folks are to focus on intellectual property. And to the extent that you have shareholders already, how do you generate shareholder value and not squander that by not focusing on protecting your intellectual property, particularly with patents. So do you need freedom to operate in your space? Of course you do. Well, will getting patents and doing things like we talked about, like cross-licensing and the like, help you with regard to avoiding NPEs in the future and things like that. But that's just some of the points here in this slide that I want to point out. Clearly, differentiating your competitors and in the marketplace, and is your type of intellectual property the sort of thing that you can direct patents to, and then turn around and use those patents in your marketing materials, build on your IP that way, where you kind of get a virtuous cycle going to be able to have one work off the other. The whole ROI is, creating your market share, being able to see in the future a little bit and beyond the next hill, and where's the market going, and you want to time the protection of your intellectual property in that way as well. We talked about maybe, filing too many patents too soon could be a problem. We're not filing enough patents soon enough. Really, it depends on your ability to have your teams work together, your marketing teams, your R&D teams, to figure out how that timing is going to best leverage your assets that you're able to put in to your intellectual property to do that. Monitoring of the competitors too is a costly thing. So got a couple of slides we'll come up with in a little while that merely kind of link up some of the timing aspects with regard to that. Michelle, if you could jump to the next one there for me.
Just real quick, I just wanted to make two quick comments. One, to Don's point, it's funny how many companies we work with who tell us, as they are asking us to file patent applications for them, that they don't ever intend to enforce their patents. It is actually a common strategy that some companies obtain patents without the goal of actually going out and suing somebody. And I just wanted to highlight that because there's a lot of reasons that, when you're looking at an overall IP strategy, which doesn't include just patents, but also includes, for example, trade secrets, some of these things that Don mentioned, like showing your technological leadership or distinguishing your product from your competitors, if you're keeping some information as trade secret, you can't use that information to publicize your company. And so there's that balance of if you know that you're going to need to make information public, then maybe you need to file a patent on it, even if you're not planning on actively going out and enforcing your patent yourselves. Maybe 10 years in the future, you get acquired by another company who does want to do that, or it gives you an opportunity if someone comes after you. Now you have an ability to do a cross license. And so some of these issues, I know we're talking a lot about patents, but it's really all because we're, the IP strategy looks at everything and what is the role that each of these play.
And we need to have an IP plan in place, and we can't ignore the business and the planning and business strategy here as well. They need to work together because we can't have internal meetings over the coffee machine or the water fountain and have the marketing folks talk to the designers or the engineers or the investigators about something new that's been invented, and then all of a sudden that gets into marketing materials and gets out, and the left hand doesn't really know what the right hand's doing, and you've kind of leaked the information, and we're now, like we mentioned earlier, that Steph pointed out, that we're in a first to file environment, and if the invention is ready for patenting, but enough material is leaked in the marketing materials that someone else, can kind of, put two and two together and figure out where you're going, and they have their own spin on it and file something before you do, that could be really detrimental. So again, we need to link these departments up, these teams up, and make sure that things are properly timed, and everyone in the business side of the shop is aware of what's going on as well. Brand protection, we kind of talked about that a little bit. Life cycle, certainly talked about that. Again, for electronics, the life cycles are much shorter. For biotechnology and molecules are just small. You need to work on that timing differently. You've got to go through the FDA in some circumstances, so you don't want to get your patent too soon and not be able to take full advantage of your patent term. Just some other bullets on here to consider. Michelle, why don't we jump to the next one? So we've talked about having high quality and enough information in the patent applications and fast tracking to optimize the portfolio. Again, and establishing monitoring to make sure we know what the competitors are doing to identify infringers later on, and then being able to monetize the IP here and optimizing the enforcement. Go ahead and if you could, skip there. There we go. Some of the things that we need to focus on early on, and this is we have. And recommend that clients have an invention disclosure process, which is part of their product development process. So they have internal mechanisms to percolate up to management, what their ideas are, and do those ideas rise to the level of an invention, or are they trade secrets? And based on a lot of the things we've talked about, we need to weigh, some of these things we see here in question 1 and question 2, how easy is it going to be for people to reverse engineer this idea? Do we keep it as a trade secret? I've got a client where, they manufacture products and they sell this that go into more complicated devices. And it's very, very difficult to reverse engineer their manufacturing processes. But sometimes what they have to work with vendors to implement those processes. So even though it can't really be reverse engineered, if that trade secret is going to have to be shared with a partner down the line, a decision has to be made whether to actually file a patent application on what could otherwise be held as a trade secret, because you're going to have to share that with one of your partners, and you might not want to just rely on contracts for that, for some of the things we talked about before. I think we can. Again, here some of the questions we ask early in the process. We have, like I said, recommend that we use these invention disclosure processes to document these materials, to document the trade secrets as well, if you make a determination that something is kept as a trade secret or not, and to have perhaps set up patent review committees that weigh all these cost benefit analyses from a business and an intellectual property perspective, and from an IP budget perspective as well, that we have to get down to some of these questions and answer these to make a determination of whether we have to do pre-filing investigations before we do file patent applications, or we have to do freedom to operate before we figure out if there's an area that we see some white space and we want to invent in that area, and maybe adjust what the future of the business is going to be, and all these things kind of need to be thought about early on and contemplated with regard to the IP plan when we're trying to figure out that ROI. And these slides here just really kind of link up what's going on in the R&D department and at the various stages of the product development, and what the IP team needs to be thinking about at these different stages as well. And just to kind of speed things up, Michelle, the folks can read these slides. It's all fairly straightforward. So that what happens early on, what happens kind of midstream when you're filing your patent applications, and then when you have to figure out again whether you want to file internationally. Next one here, right? Your product's launched. You filed maybe your domestic patent applications or your PCTs. Now you want to figure out what other broader markets you want to go into, what other countries you need to spend money filing your patent applications on, right? And at that time, you need to start maybe monitoring the competitors again to see if again it's a cost benefit. Do we file in those countries or not? What's happened in our first filed countries? Have we got any protection yet? Have we got search results that show that we might get protection? And will that help us make decisions on whether to file in these other countries or not? And then of course that all plays into the enforcement model as well. It's a lot to cover. Sorry, it's kind of.
Thanks, Don.
I'm trying to keep Ellen and Seth awake is what I'm doing.
There's a lot of seats over here.
We understand that we are running short on time, and it's a long time to ask y'all to be sitting in front of screens. What we had next in the slides that you can go back and look at is just a specific case example of, here's what my profits would have been if I had an IP strategy, and here's what it would have been, when a competitor came on the market without an IP strategy. You can go back and look at the numbers if you like, but I think that one thing I'm really interested in hearing is Gaby talking about freedom to operate and how knowing what others are doing fits into your IP strategy as well.
Okay, thanks, Michelle. And I actually want to go to slide 79 first and then come back to 78. Because the question is, for those of you that don't have a lot of experience around freedom to operate, what does that mean and why is this important? Basically, you want to know what patents are already out there, what third-party patents are already out there that may be blocking you before you go and spend a lot of years and money developing technology, only to find out that there's 5 blocking patents that either you're going to have to get a license to or you're going to have to attack and invalidate in some way. So freedom to operate can be very important. It doesn't have to be expensive, but it's always a good idea to have at least some inkling of what your competitors may have and what other people may have around you. So this is something that I think companies do early on, just to get a high-level view of what may be there. And a lot of investors will ask, during due diligence calls, well, have you done an FTO? Who are your competitors? What other blocking patents may there be? And what is your approach to those patents? Do you have an invalidity strategy? Do you not infringe? Are you designing around? What are you doing? So this is why FTO is important. And oftentimes it's a global FTO. So it's, you want to know what's in the US, but sometimes you have completely different patents in other countries, or you may not have the patents that are blocking you in the US in Canada for whatever reason they didn't file there. So this may help your strategy, because maybe now you can do certain things in Canada that you didn't think you could do instead of doing them in the US. So a lot of reasons why it's important to know what's out there and why FTOs are important to be done. And also to keep doing them every so often, because as either Don or Michelle mentioned, once you first file a patent application, it's secret. Nobody knows that it's filed, and until it publishes, you would not know. And if it's a fast track application, it will actually issue before it's even
almost there, guys. Almost there.
I think that goes for me. Almost done. Okay, so now going back to slide 78. I think maybe with that context of slide 78, Michelle, if you can go back one, these are just questions that you would ask yourself as far as, in the company. What is your process for IP clearance? Do you have a firm, an outside firm check every month, every 3 months, every 6 months to see what else may be popping up? What assumptions are you making? Are you just looking at the US? Are you looking worldwide? Are you looking only in the key countries? When do you do it? Do you do it, at the beginning before you spend money in R&D? Do you do it sort of halfway point, or much you don't even do it at all? You just try to ignore the whole thing and see if anybody even raises anything, or get a letter that says you're infringing my patent, do something about it. And then the last question is, how do you make decisions to pursue a certain technology based on your knowledge of FTO?
And if I can just jump in real quick, Gaby, one of the things you mentioned is what's the geographic scope of where you're looking at? And I think particularly in the startup space, that's a really important question because you can't file everywhere. It's just too expensive. It's just not cost effective. And when you're dealing with software, for example, it can be generated anywhere. And so you could have a company in another country who might be able to copy it and generate it very easily. So you really do have to look at where is your market going to be? Where do you think you're going to be marketing your product, and kind of make your decisions both on IP strategy, but also freedom to operate in those countries?
Yes, thank you. And so just to quickly remind everyone that patentability, whether your invention is patentable, whether you can get patents on your whatever you've invented, that is not the same thing as freedom to operate, right? So freedom to operate is what other people have that you may be infringing, or which you may have to design around, or which you may have to license, right? It's other people's IP versus patentability. Can you get your own IP based on prior art, based on everything else? We already talked about that it doesn't give you the right to do anything, but it gives you the right to exclude others. So as an example, this key point here, if there was a patent to aspirin, whatever it was called back then, and you came up with a method of using aspirin to treat acne, well, that's great. You can exclude others from using aspirin for acne, but you still have to go deal with the aspirin patent because somebody else has that patent. So patentability, freedom to operate, related, but not the same thing. The last slide here was just to remind everyone that there's this overlaying, whole area of licensing and tech transfer and agreements, and a lot can be said about all this. We just wanted to show you the different types of agreements, the different types of IP rights, licenses. There's a lot that goes into this. In the interest of time, we can't really do it any justice whatsoever, but if you have questions about it, let us know.
One thing I think we can mention is the licensing aspect tends to dovetail closely with the freedom to operate issues. This key point that Gaby had here about you may have an invention, but then there's a broader dominant patent that covers it, your aspirin example. So that's where licensing comes in. You have an improvement, they have the base. You can't move forward because you don't have the base. They can't move forward because they don't have the improvement. And so you can cross-license, and that can be very helpful in that regard, and having something to license with. With that being said, we also have a case study here, a particular story of one that we're familiar with, where we first met a company at the seed stages, worked with them to develop their portfolio that was in line. They had a goal when they started if they wanted to be acquired within a certain time by a larger company. I was talking a little bit about the how IP played into that. I'm going to skip that just in the interest of time. I think there's probably more interest in a Q&A session, things like that, where we can answer your specific questions. But that information is here just as an example. And so with that being said, maybe I'll stop there, and Ella and Seth will go ahead and jump into Q&As, and that way we can know exactly what people want to hear about.